right. We'll call to order the July 21st, 2026 meeting of the Indiana Alcohol and Tobacco Commission. I will note that we have a quorum with all commissioners present in person. Next item on the agenda, the disposition of minutes.
Madam Chair and members of the committee, we've received a copy of the minutes of the Alcohol and Tobacco Commission meeting of July 7, 2026. I've reviewed those. They are accurate and appropriate. I move acceptance of those minutes as proposed.
Second. It's been moved and seconded. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Next item, prosecutor's recommendations.
Madam Chair and members of the committee, we received a report from the prosecutor on the alcohol and tobacco fines. In this latest term, there were 42 individual fines for a total of $23,600. 3 of those resulted in suspension of permits. 2 are worthy of note. The first comes from Bloomington at the KCMC Enterprises. Luna Patina involved a complaint of business serving minors. The officers did a walkthrough and discovered several underage subjects drinking. They then returned 10 days later in January and conducted a compliance check, and there was a 19-year-old then able to purchase alcohol. Based upon those violations, and previously once on the PACE program, parties have agreed to a combined $2,000 civil penalty and a total of 8 days suspension of the alcohol permit. The second is a tobacco permit in Vanderburgh County. It involves officers conducting an inspection. While there, they found counterfeit Zyn products, confirmed that with the Philip Morris Company. They confiscated 129 counterfeit products, and a violation was written. Parties have agreed to a $1,000 civil penalty and 7-day suspension of the tobacco certificate. I move acceptance of the prosecutor's report and information.
Second.
Been moved and seconded. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Hearing judge's recommendations. The first is on an order to show cause. That is for DL 5432373 SASR Enterprise LLC.
Madam Chair and members of the committee, regarding this permit, there was a violation filed in December. The officer conducted a compliance check, and the individuals at the building and the permit failed that check. And there was a minor purchasing alcohol at that location, and the individual employee sold a can of beer to the underage individual. The prosecutor proceeded on that, sent a notice of the violation to the settlement officer. We set a rule to show cause hearing. It was held, no one appeared, no one was present, and no appearance was filed. Exhibit 1, the officer's report on the violation was filed, indicating that the violation that was accepted. At this time, I recommend the violation be found, revocation order be held and approved, and this matter closed.
Second.
Been moved and seconded. Any further discussion? Not seeing any. All those in favor indicate by saying aye. Aye. Opposed, say no. Motion carries. Next, proposed findings of fact and conclusions of law. The first is for 2 permits issued to the same permit holder. Those are for RR 8403694 and RR 8401565, Wabash Valley Hospitality Incorporated. This matter was appealed following denial by the local board and initial denial by the commission. It was set for a pre-hearing conference at which no one representing Wabash Valley Hospitality Incorporated appeared. Following that pre-hearing conference, it was set for a substantive hearing on the appeal. Again, no one representing Wabash Valley Hospitality Incorporated appealed. Courtesy email was sent to the permit holder inquiring whether the permit holder intended to still pursue the appeal. No response, was returned from that courtesy email. The commission moved forward with findings, upholding the initial denial, at which time the permit holder did respond with objections indicating no receipt of the hearing notices. Well, I believe they were properly sent, courts generally dislike default judgments and they prefer permit holders to be engaged in, or parties, to be engaged in their appeals. So I would actually move, to set aside my proposed findings, set the matter for a, hearing on the merits of the appeal one final time for the permit holder to appear. This is a situation where there are two permits and the permit holder uses different mailing addresses for the different permits. So I would ask that we send both certified mail and first class mail with the hearing date, which is to be determined, to both addresses. Based on the documentation that's been sworn under penalties of perjury to us, one or both of those should be good addresses. If we get the certified mail back, we will count that as valid notice and we will proceed with the hearing on that date, regardless of whether permit holder appears or not. So that's my motion.
Second.
Is there any further discussion?
I will vote yes, but I've generally been in courts before. Takes a lot of time and effort and energy and work for everyone to pursue these kind of things and for a permittee to ignore them. And then when we get to the end, decide they want to do something that troubles me, but I understand your recommendation, I support it.
It's been moved and seconded. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Next is RR 02015550 Sunset Catering Incorporated. This is following a revocation hearing order.
I heard this, this permit has some history to it. I think they began business in 1992. And then sometime in January of 2025, the permit was sold to a new operator. There was a storied history prior to that with what was known as the LA Sports Bar. There were complications, so they decided to sell to someone to begin operating the business and the catering business known as LA Sports Bar. Shortly after they sold in January 2025, the permit expired and nothing was done to improve that condition and to correct it. In January of 2026, this year, the permit was made dead, having been put on the dead list, and it was placed in auction status. In sometime around April, the permittee at that time asked that it be removed from the dead list, that it not be placed at auction, and that it be put in escrow. We heard that at a hearing and approved that, reinstated the permit and put it in auction. 10 days later, on April 17, 2026, escrow got a report that they were, it looked like they were open for business and conducting business. That evening, the officer went there to find out the front door was open. There were people in the building decorating for a party, and there was a number of different items of alcohol, including open alcohol at the premises. In talking with the people there, the owner of the permit, Mr. Granadas, indicated that he was the manager. He did not say he was the president. He said he was the manager. He said that there was no alcohol permit on the premises. He agreed and understood that the permit was in escrow and they should not be open. He asked the excise officer if they could bring alcohol from another business he owned there and was told no. He asked if other people could bring their own alcohol there and he was told no. And indicated that we don't sell alcohol there. And the officer wrote a ticket for, an expired business permit. And in fact, the permittee paid that permit, violation, within a short period of time. In hearing the testimony and evidence, it became clear to me that the permittee was aware that the above permit had expired in July of 2025. He was aware that it had been reinstated. He was aware that it had been placed in escrow. He was aware that escrow did not give authority for the sale or dispensing of alcohol on the premises. He indicated there was a party and that they were preparing to conduct that with alcohol present. And that the circumstances were in violation of Indiana state law and the rules and regulations. Based upon the testimony evidence I heard at that time, I recommend, and in the order that I proposed, that the permit be revoked. Since then, shortly after the order went out, they obtained an attorney and filed objections to the order on revocation, stating a number of different issues regarding that, but acknowledged that they did have alcohol on premises, that there were open containers, and that it gave the appearance that they were open for business with the open door. He acknowledged the violation had been paid, but he added additional information that was not presented at the hearing, and is asking for the commission to consider that they are proposing that the previous owner take back the stock and the permit be transferred to the previous owner's name. In fact, on June of 2026, just a month ago, the owner, Mr. Granados, agreed to transfer the stock back to the previous owner, Ms. Trevino, and in fact executed consent to transfer the stock. They also submitted that in a disclosure of interested parties that that individual, Yolanda Trevino, would be a 100% owner, and that the manager's questionnaire would be added to show Amanda Newell, who is the daughter, would be the manager, and that Mr. Granados will have no association with the permit. While I recognize all of those things, in my opinion, since the revocation order was issued, it's questionable whether or not they have the authority to sell the permit, and questionable whether or not, even considering all of that, the evidence as presented regarding Sunset Catering Incorporated DBA LA Sports Bar violated the law. The permit had been made dead and was up for auction. We reversed that and allowed it to go into escrow so they could figure out what to do. In the meantime, they did try to conduct business. They were dispensing alcohol on those premises, and I stand by the order of revocation and move that we revoke the permit RR02 01550 for Sunset Catering Incorporated DBA LA Sports Bar.
Second.
It's been moved and seconded. Is there any further discussion?
Never like to see a permittee who has let the, his permit lapse. It was made dead, comes and asks for it to be reactivated. It's clearly stated it's in escrow. You may not sell alcohol, have alcohol on your premise, do anything with alcohol, as Judge Payne stated. And then 10 days after we reactivate, they are again trying to sell alcohol at their location. That's just really unacceptable for a permittee to act that way.
Just pointing for, they weren't selling, it, they
Well,
were dispensing it,
they
so.
had it on their own.
Yes, that's correct.
Thank you.
I would just note, you mentioned that there was a history of issues on the sunset permit. In 2019, the permit had to be reinstated following being made dead under Ms. Trevino's ownership because they had let it lapse for 3 years. Over the course of those 3 years, the commission had extensive communications about what items were missing, how many years were missing, what was needed. And part of my consideration in reinstating, because I don't think it's appropriate to reinstate a permit for the second time. But part of my consideration at that time was that the ownership of Sunset Catering changed during that time. So if I had known that we were gonna get to this point of the request of Ms. Trevino being back involved, I likely would never have voted to reinstate a couple months ago anyway, because we've already been down that road of letting the permit lapse, not providing paperwork, not responding to necessary items for 3 years. So as to the recent request, I would just say I wouldn't have voted to reinstate had she been the owner at that point anyway. So with that, I'll be voting in favor of the findings.
Just one thing to follow up on that, and I think this over and over again at these public hearings. We have more than 15,000 permits, and almost all of the folks follow the rules, get things done. They are not that onerous. I suspect at some point, a casual observer could say, whatever are you being so harsh for? These are rules set in place for a reason. They are easy to follow. The staff is wonderful in helping comply and check and make sure that everything is. This isn't tough stuff. And so at some point, like you said, the second time, it makes it easier.
Okay. All those in favor, it's been moved and seconded. All those in favor indicate by saying aye. Aye. Opposed, say no. Motion carries. Next item on the agenda, consideration of applications, 485 renewal applications.
I incorporate by reference this list of 485 applications for renewal, which have been recommended by local boards and reviewed by our staff with authority of the commission, and I hereby move for approval of same pending any needed escrow hearings and inclusion of this list in the minutes of this meeting on July 21st, 2026.
Second.
Been moved and seconded. All those in favor indicate by saying aye.
Aye.
Opposed, say no. Motion carries. Next item, 40 new and transfer applications.
I incorporate by reference this list of 40 permit applications for a new permit or applications for changes in ownership or location or both of existing permits, which have been recommended by local boards and reviewed by a commissioner. And I hereby move approval of the same pending a floor plan approval by the Indiana State Excise Police and an escrow hearing if needed, and inclusion of this list as part of the minutes of this meeting of July 21st, 2026.
Second.
Been moved and seconded. All those in favor indicate by saying aye.
Aye.
Opposed, say no. Motion carries. 57 catering applications.
I incorporate by reference this list of 57 permit applications for catering, and I hereby move for approval of same and inclusion of this list as part of the minutes of this meeting of July 21st, 2026.
Second.
It's been moved and seconded. All those in favor indicate by saying aye. Aye. Opposed, say no. Motion carries. 16 direct wine shipper applications.
I incorporate by reference this list of 16 new and renewal direct wine shippers permits, and I hereby move approval of same and inclusion of this list as part of the minutes of this meeting of July 21st, 2026.
Second.
It's been moved and seconded. All those in favor indicate by saying aye. Aye. Opposed, say no. Motion carries. Waivers of fees for letters of extension.
Madam Chair, we've received several waivers of fees for letters of extension. I move approval of those.
Second.
It's been moved and seconded. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Next, items for discussion. First is DL 4632971, Burke Liquors LLC. This is a transfer with the local board voting 3-0 to deny.
This comes to us from LaPorte County, specifically, a small city called Trail Creek. This permit, I'll note, was issued some 4.5 years ago. It was issued into escrow. It now has a location, and they have done, it looks like, some very extensive work to get, their building location up and running. It has now come to light that the permit that was issued 4.5 years ago to Trail Creek is questioned because of a permit that was issued some 12 years ago to Michigan City, which actually should have been in Trail Creek. Which means that Trail Creek, because of their population, they're only entitled to one packaged liquor store, so this caused a second to be issued. I'll note that this previous permit that was issued some 12 years ago, the application that came in mentioned that it was for Michigan City. The survey form from the county surveyor that came in stated it was also for Michigan City. So therefore, that's why that permit was issued for Michigan City. But then much later, it came to light, just in the last little bit, that that permit should have actually been in Trail Creek. So that's why we have this problem of 2 permits that have been issued in the Trail Creek area that only has population for 1 packaged liquor store. They're not over 8,000 in population. There were quite a few people who attended this local board hearing. I think all of them were in support of this first business that got their permit, Madeira, that was issued from Michigan City. There was also remonstrators who signed a petition, quite a few, who were in support of the first business, Madeira, and do not want this second liquor store, Burke, to be issued. The problem is it was already issued some 4.5 years ago. I don't, the Burke who came in, it appears to me, has done everything correctly 4.5 years ago. They went through a public hearing, they were vetted. That permit has been in escrow for some 4.5 years, and now it looks like they're ready to go into active use. And I find no reason to not continue with the issuance that we've already granted on that permit. That will cause 2 permits to be in Trail Creek. But it's something that originated 12 years ago from the Madeira permit that was issued for Michigan City, which is kind of impossible for us now to take care of. So with that said, I'm going to vote, because of contrary reasons to the law, that we overturn the local board and allow this permit, DL 4632971 Burke Liquors LLC, to proceed with its transfer location and for it to remain an active packaged liquor store permit.
Second. Been moved and seconded. Is there any further discussion?
I would just like to comment that some of you know I had surgery earlier this year that the doctor described as interesting. And I'm told that you never want to have your doctor say, that's an interesting case. Well, I've been doing this now for 4 years. This is an interesting case. And it took me 3 or 4 times to really read it and understand what you described. And it strikes me that an error was made. It was no fault of the permittee application originally. or the resulting purchase that we're now dealing with today. And while it on the face seems difficult to understand, a mistake was made and we're correcting it. So I appreciate your explanation. I'm intending to go forward this as an interesting case.
It's been moved and seconded. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Next item for discussion is RR 2143999 L Campa LLC. This is new, the local board voting 4-0 to deny.
This comes to us from Fayette County. The applicant, has possibly 4 or more different, identities. So there's possible false ownership. There are possible criminal convictions with those ownerships. It was hard to tell with all the multiple names that were used and identities that were used, and to try to follow back and see if there were criminal convictions. It's difficult to know if there's any problems with this or not. Local board, I think, appropriately voted to deny the issuance of this new permit, and I move that we uphold the local board's denial of the new permit to RR 2143999 L Campa LLC.
Second.
It's been moved and seconded. All those in favor, or is there any further discussion? Not seeing any. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Next item for discussion is DL 8733710 Rudra Inc. This is a renewal of the local board voting 2-1 to approve.
This comes to us from Warwick County, and was up for renewal. The owner did appear, he had a violation. The violation had to do with, selling unlawful, THC products. I will note that the owner did state that he's only had this for a shorter period of time. It was transferred to him. The previous owners were selling these products. He continued selling them. He thought they were legal. He was buying them from a wholesaler. He also thought that the products he would get from a wholesaler were legal. He did mention that he does sell in another state and that these products are legal in the other state, but he now understands that they are not approved for Indiana. The products in question had been removed from the shelves and were in a box, but they were under the cash register. They still had price tags on them, so maybe they were still for sale, hard to know. But the owner did sound remorseful, did admit that these products, he had purchased them, he was selling them. He had taken them off the shelf, was not selling them any longer. He appears to understand now the law and said he would check with the ATC on any sort of products that are questionable in the future to make sure that he can sell them. I'm going to move that we uphold the local board and allow the renewal of DL 8733710 Rudra Inc.
Second.
Been moved and seconded. Is there any further discussion? I would just note that for me, I'm voting with the 2 board members that voted to approve. For me, this is a strict compliance issue. Well, yes, the permit holders said that they were removed, they weren't for sale. Excise has frequently found permit holders that place their illicit products beneath the cash register, only sell them when asked for. So this is a behavior we do see. So for me, this would be strict compliance that in the future, if there are illegal or illicit products at the location, I'll be switching my vote. So permit holder knows what needs to happen moving forward, and we expect that happen. Any further discussion?
Agreed.
I agree too. All those in favor indicate by saying aye.
Aye.
Opposed, say no. Motion carries. Next item for discussion is DL 883030 Apples Treetop Liquor LLC. This is a renewal. There was some confusion on the escrow expiration date, I believe. The escrow permit must be active or transferred on or before September 13th of 2026. So the renewal for this next period is a valid renewal, so I would move to renew the permit.
Second,
Is there any further discussion? Not,
that if it's not placed into active use before September 13th, that permit will revert to us. Just, I think the applicant or the permittee knows that, but just again, for the record, need to make it active before then.
it's been moved and seconded. All those in favor indicate by saying aye.
Aye.
Opposed, say no. Motion carries. Next item is RR 4944040 TL Entertainment LLC. This is a remand request from the local board.
Yes, this comes to us from Indianapolis. The notice to the neighboring property owners was not sent timely. They didn't get a full 15-day notice. This did not come to light until after the local board had already voted on this matter to renew the permit. And now they're asking for a remand, so there is proper notice. And there are remonstrators or anybody wants to come to the local board, they can do so. And so I move that we remand this back to local board for RR 49444040 T Lee Entertainment LLC.
Second.
It's been moved and second, excuse me, it's been moved and seconded. All those in favor indicate by saying aye.
Aye.
Opposed, say no. Motion carries. Next item, WH 4930104 and WH 4930105 DME Spirits LLC. This matter was set today following a prior hearing on an investigatory hearing on the renewals. It's a lengthy file, and I know that I am personally still reviewing it. So I would move to continue this to our next commission meeting
August 4th.
on August 4th.
Second.
It's been moved and seconded. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Next, permit is CH 1830190, the North Church Venue LLC. This matter comes on for an extension request.
Yes, this comes to us from Muncie. They did expire April the 18th of this year. They had an extension from April the 20th to July 19th. We were waiting for some paperwork. They've now gotten that to us. They are scheduled before the Delaware Local Board on August the 6th. I move that we grant a second 90-day extension for CH 1830190, the North Church Venue LLC.
Second.
Been moved and seconded. Any further discussion? Not seeing any. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. The next permit is RC 2800112, the American Legion Frank Courtney Post 22. This comes on for an extension request.
This comes to us from Linton. This is a fraternal club type permit. They did expire April the 1st. They did have an extension from April the 8th to July the 9th. They had some paperwork that we were waiting for, which they've now gotten to us. They're scheduled for their renewal hearing in front of the Greene County Local Board on August the 3rd. I move that we grant a second 90-day extension for RC 2800112, the American Legion Frank Courtney Post 22.
Second.
Been moved and seconded. Is there any further discussion? Not seeing any. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Next permit is RR 1019620, Kansai Japanese Steakhouse LLC. This comes on for an extension request.
This comes to us from Clarksville. The permit did expire March the 5th. And I note from the Secretary of State's office that they, on March the 6th, they voluntarily dissolved this corporation, and that's of this year. They did come before us on June the 16th to ask for an extension. We did give them a 30-day extension until today and asked that they follow up with the Secretary of State's office and get their certificate of existence for their company, Kansai Japanese Steakhouse LLC. We have not gotten that corrected information. We did get a response back from them saying that they do have it, but it looks like they have changed their corporate name and they have a new certificate of existence for the new corporation, but not for the company that they have a permit with us. So I'm going to move that we grant a 2-week extension until that August the 4th date, and ask legal if, Daphne, if she could maybe call and send them a letter and explain that we need the certificate of existence for the Kansai Japanese Steakhouse LLC name, not the new name. And they need to take care of that in the next 2 weeks. And that is my motion for bar 1019620 Kansai Japanese Steakhouse LLC.
Second. It's been moved and seconded. Is there any further discussion? I would just note that it seems like the permit holder may be intending to transfer to the new corporation, but it's not legally a transfer until the required transfer documents are on file and approved by us. So, if legal could include information about the transfer process, and that the concern is there is no liability protections for this corporation right now as it stands,
Right.
because they hold an alcohol permit in a corporate name that no longer exists. The other corporate name does not hold an alcohol permit. And so any alcohol they believe they're selling under that corporate entity is being sold potentially unlawfully. So maybe include in there the transfer paperwork that we need.
Do they have a certificate of insurance on file in the permit holder name? Do you know? I can look it up.
I don't,
I'll check on that too, because they need the insurance in the right name
Yeah.
to cover the permit.
so, yeah, 2 weeks to get this straightened out paperwork with us. I'm fine with that. Any further discussion?
That's pretty serious, though, frankly, I think. They can't just transfer back and forth and pretend that they have complied with all the rules and regulations and laws of the state of Indiana. People create corporations for a variety of reasons, and you can't just say, oh, we're gonna do it now under a different corporation and let this one die. So I think they have a lot of work to do very quickly here, but it should have been done months ago.
All right, it's been moved and seconded. All those in favor indicate by saying aye.
Aye.
Opposed, say no. Motion carries. Next item for discussion is RR 1240326 Rios Events LLC. This matter comes on for an extension request.
Yes, this comes to us from Frankfort, Indiana. The local board did recommend a denial. We did uphold that. I believe there were some issues on ownership and possibly other things. It did come before us on June the 16th. We did give an extension until today, asked that they file for their appeal. They did timely file for their appeal. They have hired counsel. There is a pre-hearing meeting scheduled August the 20th. And I'm going to move that we grant the rest of the extension that we issued on June the 16th. For the full 90 days, starting June the 16th. And that is for RR 1240326 Rios Events LLC, so they can work through the appeal of the denial.
Second. Been moved and seconded. All those in favor indicate or is there any further discussion?
No.
Not seeing any. All those in favor indicate by saying aye.
Aye.
Opposed, say no. Motion carries. Next item for discussion is RR 7940427, Brusco LLC. This matter comes on for an extension request.
Yes, this is in Lafayette, Indiana, in Tippecanoe County. They expired on April the 8th, 2026. And we gave them an extension from April the 7th, 2026 to July the 7th. And then there was a letter of authority that extended them until today, the 21st of July. They don't have any violations. So I move that we offer them another 90-day extension to Brusco LLC, RR 7940427.
Second.
Been moved and seconded. Is there any further discussion? Not seeing any. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. There is one additional extension that came in, and that is RR 7241079 Java Station Incorporated. Can we take it by consent to add that to the agenda?
Consent.
Second.
Show that added to the agenda by consent and open that for discussion.
Yes, so Java Station Inc. is in Scottsburg and their permit expired on April the 17th, 2026, and we gave them an extension until July the 16th, 2026. They still have several things that are, they need to get to us. But I would say that we give them a 90-day extension conditional upon us receiving a certificate of insurance, and that 90 days would start as soon as we get our certificate of insurance. But note that there are other things they need to get us, including property tax clearance form and sales figures.
Second.
Been moved and seconded. Is there any further discussion? Not seeing any. All those in favor indicate by saying aye.
Aye.
Opposed, say no. Motion carries. Next is inactive files. There are 18 permits to be made inactive.
Chair, members of the committee, I incorporate by reference this list of 18 permit applications to be made dead as they were identified on July 7th, 2026, and move that they be included in the minutes of this meeting of July 21st, 2026.
Second.
It's been moved and seconded. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Note there are 2 permits to be made inactive on August 4th, 2026. If we do not receive renewals on those. I will just note that there are permits set for August 4th, 2026, where we are missing items. People have been notified once, twice, 3 times, all of the above, of what missing items are needed. So those have to be to us before August 4th, 2026, or we will reconsider the grant, the conditional grant of those renewals. There is one meeting date in November that's changed. Not seeing any other items on the agenda. I would entertain a motion to adjourn.
Move to adjourn.
Been moved and seconded. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. We are adjourned.
Welcome back, Chair.
Thank you.